Why don't we begin?
Good evening, everybody. Good evening. If I speak sort of here, can you hear me? At the back? Good. Okay. Louder. Okay. I'll put the microphone a little bit forward. Welcome to the Future of Human Rights. I was going to start with "We are the future of human rights," but I thought that we'll leave that sort of corniness till the end. My name's Adam Wagner. I'm a barrister, and I also edit the UK Human Rights blog. Some of you may be here because you saw this advertised on the blog. We've got a fantastic event planned tonight. We're going to finish at 8:15, at which point you're all very welcome to stay for a drink, and there'll be a few canapes as well. The evening is going to it's going to be in three parts, with the third being the canapes and drinks, so that's the one to really look forward to. First of all, before we move on and I'll introduce the fantastic panel we've got to discuss the topics this evening. First of all, what we're really here to do is to launch a book, and the book is here. I'm fairly sure there's enough copies that everybody can buy one this evening and sign by the author. The book is by Dr Rosa Freedman. It's called Failing to Protect the UN and the Politicisation of Human Rights. Now, Dr Rosa Freedman is wrongly described in the back of the book because she tells me she is now a senior lecturer, not just a lecturer at Birmingham Law School. She's the author of the United Nations Human Rights Council, A Critique and Early Assessment, and has published many academic and media articles on the UN, international law and human rights. I'm not going to introduce the book to you. We're going to leave that to Rosa, who's going to speak for about 5 minutes and try and explain what exactly the book's about. So thanks very much, Rosa.
Thank you, Adam, and thank you in particular to Alison and to Nikki for organising this event at BLP. I'm particularly pleased that we've got such a stellar lineup on the panel. I have my former tutor in my LLM and PhD examiner, Philippe here. And I also have next to me Jane Connors, who has introduced me into the UN world and has really enabled me to do this work and this research. We also have Subhas, another UNer, and Professor de Londras at the end, our expert on European human rights. I want to thank you all for coming out tonight and for promising to buy a copy of my book. It was very kind of you. I was asked if I wanted to read a passage from the book, but since you're buying a copy, I didn't think I'd do that. I thought instead I'd explain to you why I wrote the book and the aim of it. My research and my work focuses on the United Nations and international human rights law, which invariably leads to those very awkward dinner party moments where people say, what does the UN do? Why does it fail to protect human rights? What about Syria? What about North Korea? Why do you bother working on it? And I try and explain it in 3 sentences, normally over a glass of wine, and it doesn't work very well because it's a complex organisation. But these are really important questions. They're crucial questions for our time. And so I thought instead I'd write a book that's accessible and that's interesting to people that don't work within the world, but people that want to know what's going wrong and how we can fix it. Philippe doesn't realise this, but he inspired me to write this book. He wrote a book called Lawless World in 2005 that did exactly the same thing, albeit on a different topic. Took very complex legal issues and explained them to the wider public. This is my aim. My aim is that you'll all pick up this book, and by the end of it, you'll be inspired to do something about it. I start in the book by explaining what international law is and what it isn't. I explain how the UN works, what human rights are, and I use personal anecdotes from being at the UN. I use media stories, I use stories of tragedies and other people's voices interspersed to explain these issues. I then turn to politicisation, why it is that the UN fails to protect human rights in closed states like Zimbabwe and North Korea, in powerful states like the US and China and Russia, but also in countries around the world, in Canada, in Ireland, countries across Africa, to try and draw out all of the important issues. But then, being an optimist and an idealist lawyer, I look at reform proposals. How can we make this better? And I set out a few different proposals, none of which are the perfect solution, but all of which are there to try and inspire everyone to think about proposals that they would table, reforms that they would like to see take place. I hope that you're going to enjoy tonight's event. I hope that you'll enjoy reading my book, and thank you very much for coming.
Now we're going to move on to part 2, which will be the main section of the evening, which is the panel discussion, hopefully aided significantly by interventions and contributions from the floor on the future of human rights. I should mention now that the event is being recorded. There's a video recorder at the back. Where are the cameras? Who knows? You're all being watched. The event's being recorded, so that means that if you want to ask a question or make a comment, we've got roving mics, but if you don't use the roving mics, then you won't be heard on the recording, so please do use the roving mics. Now, I'm going to introduce the panel now. Forgive me that this is going to take a little bit of time, because that's the problem when you've got such a distinguished panel. They've done a lot in their lives. So we'll start with Philippe Sands, who is to my right. He's Professor of Law at the University College London and a practicing barrister and co-founder of Matrix Chambers. He acts in cases before international courts and tribunals, including the International Court of Justice, and sits as an arbitrator in international investment disputes and on the Court of Arbitration for Sports. He's the author of, as Rosa has already mentioned, Lawless World in 2005 and Torture Team in 2008, and has written several academic books on international law, contributes to the New York Review of Books, Vanity Fair, the Financial Times, and The Guardian. His new book, working title The Great Crimes, will be published by Alfred Knopf in 2015. So that's Philippe Sands, QC. Then to Philippe's far left is Jane Connors, currently Chief of Special Procedures Branch at the United Nations Office of the High Commissioner for Human Rights, which supports the majority of the thematic special procedures and special procedures system as a whole. She's worked at the UN since 1996, and when she took up the post of the Chief of Women's Rights Section at the Division for the Advancement of Women in the Department for Economic and Social Affairs. Before joining the UN, she was a law teacher at the School of Oriental and African Studies at the University of London, the Universities of Lancaster and Nottingham in the UK, and the University of Canberra and the Australian National University in Australia. She's written widely on the work of the human rights treaty bodies, violence against women, and the human rights of women. Fiona de Londras, who sits at the far right, is a professor of law at Durham Law School, where she's also co-director of the Durham Human Rights Centre. She joined Durham in September 2012 after 4 years at University College Dublin. She holds visiting chairs at the UNSW School of Law in Sydney and University College Dublin School of Law, and is a global affiliate of the Vulnerability and the Human Condition Initiative of Emory University in Atlanta, Georgia. She's co-editor of both Legal Studies and the Irish Yearbook of International Law, and founding editor of the collaborative project Human Rights in Ireland, which is fantastic, and I greatly recommend it. It's the only real competitor to the UK Human Rights blog, but luckily it's a different jurisdiction. Fiona is widely published in human rights, and having published 8 authored or edited books and over 60 articles and chapters, as well as dozens of online and traditional media pieces. Her work focuses on 3 areas: counter-terrorism and constitutionalism, regional human rights protection with a particular focus on the ECHR, and comparative constitutional law. She's currently leading a major international collaboration funded by the EU, entitled Cecile, Securing Europe Through Counter-Terrorism, Impact, Legitimacy and Effectiveness, and has just completed the British Academy-funded project on the role, limits of and potential of judicial review in the counter-terrorist context. And then last but not least, Subhas Gujadhur is director at the Universal Rights Group. He's a diplomat with over 15 years of experience of both bilateral and multilateral contexts. Most recently, Subhas served on the Mauritius permanent missions in New York and in Geneva, where he focused in particular on human rights and international human rights system. From 2008 to 2012, he was Mauritius's chief negotiator in the Human Rights Council. And earlier in New York, he held various senior positions, including that of Vice President of the Special Political and Decolonization Committee of the United Nations and Secretary of the Ad Hoc African Working Group on the Reform of the United Nations. He acted as moderator for the Office of the High Commissioner for Human Rights. So a well-qualified panel to speak to these issues. And what we thought would be a useful starting point is if everyone just has a couple of minutes to highlight what they think are the 3 or so main challenges and the 3 or so main opportunities to human rights in the medium to long term. So should we start with Jane Connors?
Thank you very much, Mr. Chairperson, and thanks. I'm very glad to be with these wonderful panellists, and I see that my biography is shorter than everybody's, so accordingly I'll speak longer. I'm very happy to be here. I'm seeing some old friends and hopefully some new friends, and I'm really glad that we can have so many people who could be out drinking, looking at the future of human rights. I'd first like to congratulate Rosa on her excellent book, and I'm certain it's going to be read by a lot of people because it seeks in a very lively way to bring what I do every day to life. As you all know, I don't agree with all the points she makes, and as I'm an optimist where human rights are concerned, I don't like the title at all. She will not be surprised that my favourite chapter is "It is not all doom and gloom." The conclusion to that chapter and her concluding observations to the book, however, as a whole, make me feel that we're not very far apart. Yes, grave human rights situations severely challenge our human rights system. And yes, human rights mechanisms, including the Human Rights Council, may appear to be more about promotion than protection, but these mechanisms do deliver protection. I was gratified that Rosa wrote about the special procedures system of the Human Rights Council in more glowing terms than other mechanisms, and she won't be surprised that I consider these, especially country mandates, to have great potential to protect. I just wanted to tell you about a 45, and I'm going away, you'll see it gets relevant in the end. Yesterday I had a 45-minute discussion with the mandate holder for the Central African Republic, and you know the Central African Republic is not in good shape. Her name is Ms. Marie-Therese Keita Bokum, and she previously served as the mandate holder on Burundi when it wasn't in very good shape. It's in much better shape now. She described the 2 visits that she'd made to the Central African Republic since her appointment in January, and she explained what she did in very, very optimistic terms. She's convinced she's making a difference, and she needs that optimism because it's essential for her role. She spoke of her work with the victims of violations, civil society, including religious leaders, youth, and the government. She spoke of how important it was to the people of the Central African Republic to believe that they are not forgotten and that violations can stop, as well as to hear that human rights are entitlements of all rather than the preserve of a few. The Council's commissions of inquiry, urgent debates and other tools, such as mandating investigations by the High Commissioner, have also had impact. We should not forget that the Council has been the only political body to discuss and react to Syria, while the DPRK inquiry, led by my countryman, an excellent judge, has cast the spotlight on a long-term pattern of human rights abuse as never before. So I agree with Rosa. We're looking at shades of grey, not black and white, and it's very important to bring the discussion of the record of the UN with regard to human rights protection to a wider audience. And it's very important to bring that discussion to UN bodies in New York, because there is not much of an interest in human rights. Let me talk about these biggest threats and biggest opportunities. Over the last 2 years in OHCHR, we debated threats and opportunities as we developed a management plan. And that outlines 6 priorities which we'll focus on for the next 4 years. These are strengthening international human rights mechanisms, enhancing equality and countering discrimination, combating impunity and strengthening accountability and the rule of law, integrating human rights in development, and widening the democratic space, and early warning and protection of human rights in situations of conflict, violence, and insecurity. Clearly, there are many threats, but the 3 that concern me the most are, first, the potential for states to seek to silence dissent and stifle debate on human rights issues, whether through laws or policies or intimidation and reprisals, frequently violent, against those who interact with UN human rights mechanisms. Second, conflicts involving armed groups which deliberately target civilians and which will more and more rely on highly technical means of warfare, such as robotics and drones, in respect of which international human rights law is at the developmental stage. And third, deepening inequality within and among countries, which will fuel instability as the poor and marginalised, such as irregular migrants and the Roma, are more and more excluded from all forms of decision-making. The opportunities. Now, I'm a UN staff member, and for me, the heightened role that human rights has now in the UN system. We have the Secretary-General, who's formulated a Rights Up Front action plan, which seeks to make rights front and centre of all of the work of the United Nations. We'll see how it goes. We see also that the Security Council has seen itself more open to human rights. So my boss has briefed the Security Council more than all of the former human rights commissioners have done combined, and we've seen more and more ARIA formulas. The second is the currency human rights now has among ordinary people around the world. And you're not ordinary people, but it shows that this currency is there, and I think this will get better. My communications colleagues regularly report on the large number of people watching the webcast of the Human Rights Council. They've obviously got nothing to do, but there are millions who watch the webcast of the Human Rights Council, and Rosa watched the webcast of the Human Rights Council while we were selecting mandate holders and immediately emailed me, "This looks horrible," and indeed it was. So this visibility of human rights would have been unthinkable 20 years ago. It can only continue. And as to three, that's the opportunity presented by the Human Rights Council and its mechanisms, including the Universal Periodic Review. Obviously, there is politicisation. There's going to be politicisation in a political body. But there we are. Thank you.
Do you want to go next?
Okay. Thank you very much, Adam. And I won't be as long as my previous colleague. Well, the three main threats which we see is, first of all, national security and human rights. We have seen, in many of the full-fledged democracies in the world, the issue of national security. There's this debate about how to put the balance between national security and also preserving the obligations of states under various human rights treaties, but including also within their own constitutions which promote and protect human rights, and also with their international and regional obligations. The second threat which we see, and this also has been observed by the EIU Economics Intelligence Unit Democracy Index, has been a regression in civil and political rights, which also has been coupled with, this is the analysis of URG, appearance of which we call the third generation of rights, such as the right to peace, traditional values, family values, which is currently now being discussed in the councils. Our analysis also shows there has been a backslide in the level of democratic governance and civil liberties in the world. Currently, as EIU also demonstrated, it's like only 11.3% of the world populations live in free and democratic societies. The covenants of the first and second covenants of civil and political rights ratification remains slow. The one which banned death penalty is only 73. Another recent agreement, the International Convention on of all persons from enforced disappearance, which came into force in 2010, has not been ratified by many states which are actually charged with executions or enforced disappearance. We have also seen in the recent past an increased attacks on journalists, especially as Arab Spring swept in the Middle East and North Africa, and even as individual and civic organizations use social media and online tools to exchange ideas and press their cause to authoritarian regimes. The second challenge, which in a way is a success also, but does pose, if not properly dealt with, is the proliferation of human rights norms. Currently, with the number of human rights treaties, which is agreed at the international level, a state has around 1,400 provisions to implement. And from a legal point of view, it can, if not properly monitored and also providing capacity building, can become a challenge for implementation. The second issue also is like the council itself, which is a newly created body, has in a way been the victim of its own success in terms of like addressing human rights at a higher political level. The UPR, which Jane has mentioned, is one of the success because in terms of the participations of ministers and higher political figures in the discussion of human rights, which is very unique. It is only now we can see like during every review of a country, you have a high-level delegation coming to the council. So you have now this political engagement at the highest political level. But the challenge is the number of recommendations coming out. Like now states are getting more than 100 and 130 recommendations. And the biggest question is like now we are in the second cycle of the Universal Periodic Review on the implementation issue. This will determine also the success or failure of UPR. And for opportunities, again, like with the creation of the council, it has provided a vast opportunity in terms of addressing human rights within the UN architecture. First of all, like the council itself, compared to its predecessor, in the UN architecture, it has moved, like Commission of Human Rights was a subsidiary of ECOSOC, but the council now is a subsidiary of the GA. So it has moved in terms of its hierarchy in the UN system. Secondly, the council itself has been, we will say, a glass half full, but they have been able to address also many situations of violations of human rights. The last one was in the March session with the adoption of the resolution on Sri Lanka, which does bring the concerned government also to the debate on how to address the violations which occurred during the pre-war, post-war period. The second opportunity is a discussion which is currently going on in New York about the post-2015 development agenda and the new sustainable development goals. One of the weaknesses in the past was the Millennium Development Goals did not address the issue of human rights, while it was in the Millennium Declaration. Now the challenge is again to bring the issue of human rights within the Sustainable Development Goals, so that it does provide accountability in meeting the goals itself. And this is a big discussion which is currently going in New York, and it's an opportunity of linking human rights with development, which is very important in terms of like if we want to move, as I said, like when you have like 11.3% of world population just living in free democracy, this linkage between human rights and development has to occur if you want to move forward. The third opportunity is one big process which just occurred in New York was a reform of the treaty bodies. The treaty bodies still remain one of the most important mechanisms in terms of addressing human rights obligations by state. And the reform, again, like has in a way strengthened now how the treaty bodies are addressing human rights. But again, they have this large component which has not been addressed before, was the issue of capacity building of states who wants to improve the human rights situation, but doesn't have really the capacity to do it. That's it.
Thank you. Philippe?
Thank you. First, can I just say how very nice it is to see Rosa blossoming and moving into a situation where she's becoming a really significant figure with her writing and her teaching. And I remember her well from student days and from her PhD, and it really is a source of immense happiness to be here and see her marking the new book. I'm going to look slightly bigger picture, and I'm going to be very brief. There's so much that we could talk about. I have very low expectations about human rights, and I have low expectations because it's so new. You must, I think, not forget, but people do, and this is the first point that I make, that we forget history. Until 1945, there was no system of human rights. Until 1945, a state was entirely free to treat its nationals as it wished, as a matter of international law. So in the scheme of human existence, the changes over the 70 years nearly that have passed are absolutely extraordinary. And I think that is a matter for celebration. But we are tending to forget history. And particularly in this country, we're tending to forget history as one watches the debate that is, if one can call it that, that is going on in relation to the European Convention on Human Rights, and the real sadness of seeing a major political party like the Conservative Party find itself on the cusp of calling for the withdrawal of the United Kingdom from the European Convention. That is an absolutely tragic and incredibly short-sighted moment. But in the bigger scheme of things, what's happened over the last 70 years is a remarkable achievement. Second point that I want to make, what's the problem? The problem's obviously sovereignty. If you go back to the earliest writings on this subject and start, for example, with an extraordinary book written by a Cambridge academic in 1945, A Bill of International Rights of Man by Hersch Lauterpacht, you'll see that all of the issues that are addressed in this book were addressed by him back in 1945. He foresaw those who were actively involved, and it was a very small community then, saw what the challenges were. I've just seen this book now, and I see that one of the ideas that is mooted in here is the idea of a world court of human rights. And if you read Lauterpacht in 1945 and see what he said about that idea, he felt that it was impractical, that individuals should not have access to international courts and tribunals because they'd be swamped. The numbers would be so vast. And of course, in a sense, that's what's happened with the European Court of Human Rights. But he also raised the issue of sovereignty. And the issue of sovereignty, in a sense, is an understandable issue. It is that states and people who live within their borders wish to be essentially in control of their destinies, and they don't like it when a foreign body, peopled by foreign individuals and foreign judges, tell them what they do in relation to prisoner voting, or in relation to gay rights, or in relation to privacy, or in relation to a myriad of other issues. And sovereignty is, I think, part of the problem, not part of the solution, and where the important thinking has to be in the next phase, which I'm talking about 100 years, not 1 year or 2 years, because I think essentially what we do in the next year or 2 years or 5 years is tinkering around the margins. It's not actually going to make the blindest bit of difference. What we're talking about is the structural changes that have to take place over time. And there's an absence of ideas about where we go over the long time. We're fighting the immediate fires that we face and not thinking over the long term. But we'll come back to that, because I don't think essentially human rights is under threat. It's here to stay, it's part of the agenda, and it's here for the duration. So I think we should be looking much, much longer term. Third point is just by reference to the questions. Who are the leaders? Who is showing real leadership on these kinds of issues? And one of the related sadnesses of the last decade is that the West, or parts of the West, in particular Britain and the United States, have lost their leadership. And part of the reasons they've lost their leadership is because of the events after September the 11th and the abdication. I do a lot of work with many governments around the world, and time after time after time I hear, why should we be lectured by the United Kingdom or the United States on our domestic human rights record when X, Y, and Z has happened? And that brings me, by way of conclusion, to the International Criminal Court. You want to look at what really pisses people off internationally, go onto your computers, switch on the statute of the International Criminal Court, look at who has been indicted for international crimes, war crimes, crimes against humanity, genocide. Every single indictee is black or African. And blacks and Africans do not have a monopoly on international crime or on human rights abuses. And that is causing a major legitimacy issue, and it needs to be addressed, and it needs to be addressed very fast. Nevertheless, that said, these are long-term challenges. I have low expectations, but I'm a fantastically optimistic individual.
Yeah.
Thank you. Well, let me start by adding my voice to the chorus that is rightly congratulating Rosa on this book. writing a book is always the kind of a learning experience, which is what we say, rather than a tortured experience for the person who's writing it. But unusually enough, Rosa writing this book was also a learning experience for me, because there is a part in it where Ireland, I'm Irish, where Ireland, although described as a good guy, is also criticised for its position on abortion. And when Rosa showed me the first draft, I discovered that I, in fact, am a cultural relativist, because my answer was, it's the Constitution, Rosa. There's not very much we can do about it. So it was a learning experience for me as well. In a sense, the threats and the opportunities that I want to identify briefly could all sit in either column of threat or opportunity. As is almost always the case, that which presents a threat also presents an opportunity. And I'm likely to take a perspective that speaks a little bit more about what's happening in Europe than the UN perspective. So I guess the first threat that occurred to me that concerns me is a kind of a shifting politics. And here I mean not just a shifting geopolitics in terms of the centres of global power shifting and moving economically and politically from states that, while problematic, at least had a long history with human rights and an engagement with the rhetoric and the doctrine and the structures of human rights. So we see shifts in global economic and political power that are challenging in lots of ways, but also shifts in political mindset. The growing entrenchment of real social conservatism, including across this continent, is a matter of immense concern, and it presents a real threat to human rights. It's astounding, for example, to think that if you're gay, at the same time as having more and more countries where you can get married, you have more and more countries where you are criminalized and punished to a greater degree, because these two things are happening side by side in the same continent and in the same world, because of an entrenchment of conservatism that is really quite concerning in terms of the effective protection of rights on a day-to-day basis. I think that connects with the second concern, which also echoes something that Philippe said, and that is about the return of sovereigntism. So not just sovereignty, but sovereigntism, this idea that there are just some things that international law and international human rights law ought to have nothing to say about, that states can put up their hands and say, this is ours to think about. And again, we don't have to think beyond the continent of Europe to see this. May as well criticise my own country in A, B and C against Ireland, an abortion case before the European Court of Human Rights. The Irish government successfully, for the first time, got the European Court of Human Rights to agree that if social sentiment is so powerful in a domestic state, that can trump European consensus, so that women in one state of the Council of Europe would effectively have lesser protections than women in the other states of the Council of Europe. And that's a sovereigntist argument which exists and writes itself on women's bodies, but mostly on the bodies of minorities as a general matter in the context of security and so on. So growing sovereigntism and not just sovereignty in the strict sense, I think is a real concern and a threat to human rights. And links then to the third threat, which is the need to grapple and to really resolve questions of human security. So that includes questions of national security that have already been raised, the real threats and quandaries of trying to protect rights in the context of a national security emergency or perceived emergency, but also quotidian emergencies, poverty, food, climate change. These are disaster response. These are enormous challenges for human rights because they all connect in with the ability to effectively enjoy basic human security on a day-to-day basis, and with law's struggle to respond to that basic quotidian need. Now, those are all threats which also pose opportunities in lots of ways, and I guess that's why in some ways my three opportunities sort of mirror them to an extent. I think that the first opportunity that seems a little bit paradoxical when one puts it out there at first is austerity. Because the absolute entrenchment of an austerity narrative, while initially imposed with great success and repression, has kick-started a response around trying to innovate rights-based responses to economic harm and to economic crisis. Particularly among NGOs and civil society. That is quite exciting. I know that economic and social rights is on the agenda to speak about a little bit later as well, but this idea of austerity creating a context in which we have to be innovative to try to use what already exists in the law to respond to real need is an opportunity, even though it's a very challenging one for us in terms of trying particularly to litigate in relation to imaginative rights claims. That then connects with the second opportunity, which echoes something Jane said earlier, and I think that's popular agitation, or people's willingness to rightsify everything. In other words, people, even if it's not accurate in terms of law, and even if sometimes it's a bit frustrating for lawyers to hear people talking about a right to X, Y, or Z that does not exist as a legal matter, it is extremely optimistic, it's extremely enlightening and enheartening to see that when things are difficult and when people are trying to respond to state or multi-state oppression and repression, they reach for rights. They are something that speak to people as a political as well as a legal mechanism. And that is quite an opportunity, which is a problematic opportunity, but it is an opportunity nonetheless. And the third opportunity is increasing regionalisation. We respond at a regional level increasingly to more and more things, not just economic, trying to create trading blocks and enhance economic engagement, but we respond to more crises and threats and opportunities on a regional basis. And we see regional structures that are developing, starting to build rights in, to learn from or to mirror the admittedly problematic rights-related structures in the Council of Europe and the European Union, and to try to create regional systems that offer a higher opportunity, I think, for enforcement of rights and for the practical engagement with and enjoyment of rights than the UN might sometimes be capable of doing for all the reasons that are very eloquently laid out in the book. So those for me are 6 threats stroke opportunities that face us in the near future.
Thank you very much. I'll tell you later over drinks about the right to Kentucky Fried Chicken, which is one of the more infamous human rights newspaper stories from the UK. The first topic that I want to put out to the panel, and the way we're going to do this is I'm going to let people speak, but only for about a minute. Okay? Does everybody hear that? 1 minute. And then I'm going to put it out to the floor, just so that we've got a bit more interaction. I know that these issues are, people have opinions about them. So I want to start with something that Philippe was talking about, and something which I think all of the speakers with their different backgrounds can probably speak to and have an opinion on. And it's about the post-9/11 picture in the human rights world. Now, it's one of the strange and probably unfortunate coincidences of our UK domestic system that the Human Rights Act came into force less than a year before September the 11th, which changed the landscape in lots of ways for human rights. But the question is, post 9/11, has the West been held to the same human rights standards as the rest of the world? So post 9/11, has the West been held to the same human rights standards as the rest of the world? Who wants to start on the panel?
I can start here.
Go for it.
So just because you've already been listening to me. So I'm going to start with a really annoying lawyer's response, which is to say it depends on what you mean by being held to the same standards. Because it's remarkable that international human rights law standards have displayed real resilience in terms of their content, so that international human rights law has said, no, the right to be free from torture remains an absolute norm. the right to challenge the legality of your detention before a court or something similar cannot be compromised. The rhetoric, the normative content has not changed, I think particularly since 9/11, but the issue, of course, is that it's more difficult because of the setup of international human rights law to enforce those norms against highly problematic states and states that then get shelter from those problematic, powerful states. So they have been, if it's in terms of the standards, the content of the standards, yes, I think they have been held to the same standards, but have they been effectively held to the same standards? Then the answer is no.
Okay. Jane, would you like to go next?
I'm not very good at this, but in terms of, say, the work of those I work with, I think there has been significant scrutiny from human rights experts of the West in ways that, and I was a bit surprised that Rosa didn't mention, for example, the joint study on secret detention that was undertaken by 4 rapporteurs of the Human Rights Council, which essentially looked at all of these issues. So if you're looking at what happens in the Council, yes, you have that scrutiny, but whether that means anything is another question. And certainly when you're dealing with independent experts, they will, I always say, because I have governments talking to me day after day after day, the standard is higher when you are expected to do better, and therefore you are going to find yourself under some more scrutiny than others. Whether that makes a difference is the question, and I suppose those who are living in the United Kingdom are in a much better place than I am to answer this question, or even reflect.
I'm going to make it a bit more specific. How can there be a human rights system and also Guantanamo Bay? How do those two coincide? I'm going to put it to you, Subhas.
Well, the question is a bit tricky. But as Jane rightly pointed out, like within the council, you had a group of experts which raised the issue of secret detention, including the issue of Guantanamo Bay. But then, like we are not living in an equal world. You have inequalities in the world between the northern and the southern hemisphere. And the UN and the Human Rights Council is a political body. So it's very difficult in view of the relationship which developing and developed countries have, which you are qualified as a retailer to a customer relationships. It's very difficult for a group of countries coming to put a resolution against a Western country, knowing very well, for example, the EU is one of the major markets of this country. So how do you address this issue? No political leaders in developing countries are going to put anything like a resolution or trying to get, so because you have an unequal balance in terms of the power of the strength between developing and developed countries. And for developing countries, it's basically like their priority is to get the their development program on, and this is where the West, like the EU or the US, is one of their major markets to being able to do that. And it has worked. For example, you have many trade agreements which have helped a lot of developing countries to progress economically. So how do you address this issue of, there's an issue of inequalities between the different countries, and whether the UN can address it. Of course, you have mechanisms like the special rapporteurs. When a country goes under review, for example, in the Human Rights Committee, then these questions are raised. But again, to what Professor Philippe is saying, we have also to see like the Charter of the UN. What does the Charter say? Why was, for example, Article 27 adopted when the Charter is basically non-interference in states' affairs, and what is the strength of the of the UN to bring these issues where within its own charter it has a limitation in terms of interfering. So these are the big debates. But again, then the force is, for example, you have like organization, for example, American Civil Liberties Union, which has been a counterbalance in trying to bring all these issues on board. But the question is tricky itself, like. How do you bring the West accountable to that? Because we're not living in a equal, in a world where every states are equal and have the same strength.
Rosa.
Well, I think to pick up on what Subhas was saying, that it's actually about civil society holding states accountable, Where the mechanisms fail, the rapporteurs that went in and wrote that report in fact didn't actually visit Guantanamo Bay in the end. But the fact-finding and the information sharing means that civil societies, think tanks, but also the media scrutinise the states, they publicise these abuses, and then at a domestic level there is some level of accountability, even if it's not through judicial mechanisms.
Philippe, anything to add?
No, I mean, accountability works in complex ways. It's hard to imagine a Pinochet-type case of a leader of a powerful Western country travelling abroad and suddenly finding himself or herself under arrest. But even if accountability doesn't work in that way, the reality is the group of lawyers who conceived of the regime of torture that was implemented by President Bush, which is what it was, aren't able to travel outside of the United States because of the consequences of a series of laws that were put in place and the kind of scrutiny in UN and other bodies that doesn't produce direct judicial accountability in that hard sense, but nevertheless changes consciousness, so it becomes part of the debate. But I think the point made by Subhas is a very, very important one. We live in a lopsided world, and so long as we live in a lopsided world, those kinds of inconsistencies and double standards are going to continue, and they will inform the way in which these issues are addressed.
Questions, comments from the floor? I think our roving mics are here. Okay, it's a lady on the left-hand side of the aisle. If you just want to introduce yourself and keep your question or comment to not under a minute, please.
Okay, my name is Elvira Dominguez Redondo. I'm a lecturer at Middlesex University. I just wanted to pick up on this point of sovereignty. Yes, because I think there's also very simplistic approaches to this. The return to sovereignty, I think, is not only related to some kind of ill-intention, I don't know. I think that a lot of it is because we have realized that international organizations and the international in general can cause harm to. And things like liberalization of trade, the World Trade Organizations, and other issues have contributed to a system where states cannot protect themselves and their population, for instance, to subsidize food and grain. So I think it's much more complex than only one direction on why there is a claim to go back to sovereignty. And that was my only comment. Thank you very much.
Anybody else? Okay, at the back.
Mira McCarr. Public company director, chartered accountant. I was very taken by the comment about media scrutiny, some degree of accountability, even if not in the judicial system. In the last few years, we've witnessed in the UK what I can call, I think accurately, the breakdown of the adversarial system. By the proliferation of litigation funds, which means that people can use the courts anonymously to torture people, kill them, and pull down businesses. It seems to me that in those circumstances, we have a problem. We have a problem with our courts, and the civil courts are being used essentially to circumvent the criminal courts. That leaves us as a nation in quite a vulnerable position. I'd like to hear a little bit more about the importance of the media, because the media has had a hammering, and the media finds it very difficult to do proper investigative work, properly supported, which takes time. I've just been supporting some people who've been supporting a financial journalist who's done an article which was very, very important. It's been taken well. But it took him 2.5 months full-time. The support team, 2 full-time people who've been victims of financial crimes and witnesses as well, and with other support. That's a lot to produce one article. And those people, that sort of exposure is not financially supported. So I would like to hear about the importance of the media, please.
I'm going to put that to the panel, and I'll slightly rephrase it. in the world in our new world of social media and the internet, are human rights being protected in ways which international institutions, first of all, wouldn't have dreamed of when they were set up? But also, is the fact that norms are much more proliferated through social media and those sorts of fora, does that mean that international institutions become less important in highlighting abuses and the like? So, Rosa, you're laughing. So
smiling at Jane.
Yeah.
The lady at the back, her question makes me think about whistleblowers, actually. And how do we protect whistleblowers, particularly in terms of social media, where it's so easy to find out where a person lives, who they are? Can we protect their anonymity? Can we protect them from human rights abuses? And that bridges into your question. On the one hand, the social media in Turkey or in Egypt helped us to understand the very many abuses that were taking place, helped to provide scrutiny which we would hope leads to accountability, but also led to people being very vulnerable and to people being threatened. And to people losing their lives or being imprisoned because they can be found. Once you leave an internet trail, despite this new ruling on your right to be forgotten, you can be found and you can therefore be victimised. And I'm not sure how we address this, but I think the UN is starting to talk about it. There is starting to be discussion. In fact, there was discussion last week. Frank LaRue, the Special Rapporteur, but this is something that, in many ways, hearing people talk about Twittering at the UN tells us that perhaps it's something for our generation to be bringing up and to be addressing.
Any other comments on the role of the media?
I mean, I think that the media has always played a fundamental role in accountability when we think about accountability broadly, beyond legal accountability, not only in terms of stimulating political accountability, but also in terms of creating a momentum towards legal accountability mechanisms where there had been, for whatever reasons, some reluctance in that relation. So in terms of there is a challenge for traditional media in resourcing and so on of investigative journalism. I think that's entirely true. But we do also still have newspapers and organisations that invest heavily in investigative journalism. And we do have people who recognise that the way in which to stimulate accountability is to get information out there. So you have Chelsea Manning, you have Edward Snowden and so on, both taking very different approaches. One, a complete dump, which is highly problematic in lots of ways, and one, a more measured, selective system of trying to use leaking well without jeopardizing security to try to create accountability. I mean, the media continues to play an important role, but there is a challenge for that. That role has to also be responsible. There is, a difficulty in just dumping thousands and thousands of documents online with no redaction and no protection for people. So building up new journalistic ethics around how we do that is an important part of ensuring that it can be effective in terms of keeping trust, that people will trust those systems to bring about accountability without risking too much in terms of people's security.
Anyone else?
I think this is a very interesting question because it cuts both ways, doesn't it? The media can be great and wonderful, but I'm just reflecting on the two most recent visits of special rapporteurs to the United Kingdom. One, the special rapporteur on the right to housing, and you might remember or you might not, that at one point she used the phrase bedroom tax. She only used it once, but she had a lot of difficulties because she was a woman, she looked unusual, she had pink glasses, there was just, I suppose, more or less an attempt to a feeding frenzy with regard to this woman, who said many other very interesting things. And indeed, in terms of issues relating to austerity policies in this country, I imagine others are saying those things as well. And secondly, you had a recent visit of the Special Rapporteur on Violence Against Women, and she's middle-aged. wears funny clothes. She doesn't have pink glasses. I think her glasses are less pink. But again, you have the media, and in some ways this worked well because a lot of debate occurred because of what was said about both of these women by, I don't know whether you call it the media, the Daily Mail. But going back to what as I say, my communications colleagues telling me in the morning meeting that we've had X number of tweets relating to the internet panel, for example, well, that's a great thing. And then there are tweets and so on and so forth. So I think what we're getting is the more people talk about human rights, the more people know about human rights, and certainly not people of my generation. I mean, I call it tweetering, and it's twittering rather than tweets or whatever it's supposed to be. So I think this is going to continue and continue and continue. But as I say, it might cut both ways. Thanks.
That's just reminded me that I should have mentioned there's a hashtag for this evening, which is Future of Human Rights. But Philippe, anything to add?
No, I mean, the media is important. We know the media is important, but the media can play a positive role and a negative role. You mentioned the Edward Snowden story. It's been very striking how little media attention has actually been given to the Edward Snowden story. Most of the newspapers in Britain have not touched it. The only newspaper that has been willing to touch it is The Guardian, to a lesser extent The Independent. But the mainstream large media, the Times, the Telegraph, the Mail, have generally avoided. And yet it's the biggest story around. I mean, we have learnt through Edward Snowden's revelations the full extent of our intelligence services surveillance of every single phone call we make, of every single email we make. And the reaction in this country generally, outside of a small group, has been a great silence. So what's caused that? If the media had reacted differently, a lot more people would be agitated about it. But the fact that they don't react to it for whatever reason, and we can speculate onto what those reasons are, indicates firstly the power that they play, but secondly the extent to which people in this country are not willing to engage with those issues. In the United States, there's been an extraordinary debate about the Edward Snowden thing. Not vicious attacks on Snowden, although there have been those, but a recognition that the United States had crossed a tipping point and that it was now becoming a state in which the power of the big state, assisted by large corporations, was trumping the rights of the individual and the right in particular to have a high degree of privacy. So I think we understand from that the media's role in all of these matters is incredibly important, not only what it does address, but what it doesn't address.
I'm going to move on, as interesting as that topic is, to something quite different and something a bit more local, and that's the European Convention on Human Rights. The European Convention on Human Rights celebrated its 60th birthday last year. Will it reach its 70th birthday? That's the question.
Well, I'll start. I served on the government's commission on a Bill of Rights.
I notice it's not on your CV.
Oh, it is. No, it is. No, it is. I'm very proud of my public service on the commission on a Bill of Rights. I was happy to do it completely unpaid, but I was outvoted. We were all reasonably well-paid barristers, etc., and so everyone could have done it without taking a penny, but the majority wanted dosh in order to do this. So it was fascinating. There were 4 appointed by the Tory side, there were 4 appointed by the non-Tory side. We had a chair who was in an absolutely hopeless situation because of the differences and the divergences. But I learned a lot from that, and I learned in particular that from some of my good friends on the Tory side, what they're willing to say publicly and what they're not was shocking. 3 of the 4 Tories would like to leave the European Convention on Human Rights tomorrow. In private, that is what they say. The reason for a British Bill of Rights, in their view, is to allow the United Kingdom to leave the European Convention on Human Rights. That is why I opposed a decision by the Commission to move for a British Bill of Rights, because it was not a genuine commitment to a Bill of Rights, which would be the kind of Bill of Rights I would care about, but a pretext for withdrawing from Europe because the European community pisses them off and the European Court of Human Rights pisses them off. And it's basically a knee-jerk, ill-thought-out reaction. So will it be around in 10 years' time? Absolutely it will be around in 10 years' time. There is no question. It is not going to disappear. The United Kingdom will not withdraw, and it will continue to be around. Does it need reforming? Absolutely the court needs reforming, but that's a different set of issues. Interestingly, and it comes back to the very first point I made, the problem that has arisen in the United Kingdom is that the kinds of people who want out are the kinds of people who have forgotten history. And I was at a meeting, in fact I'm delighted to see that Subhas is Mauritian. I've just been doing a case for Mauritius against the United Kingdom on one of the great human rights horrors of the 1960s, which is the issue of the Chagos Archipelago and Diego Garcia and the total expulsion of 2,000, all the inhabitants of a British territory. We've just had a 3-week hearing in that. But the United Kingdom was represented by the Attorney General at that hearing in Istanbul. And in a private conversation, because we were all staying in the same hotel and you sort of go in for breakfast and bump into each other, he did say that one of the because he's got a very reasonable position on the European Convention, I have to say. He's a very fine Attorney General. And he said one of the interesting things that everyone has now seen with the Russian efforts to destabilize the Ukraine and the European community's pathetic response and contribution, frankly, for the situation, is all of a sudden people have woken up and thought, wow, there's some people out there who want to do some things that we don't like, and maybe actually having a European Convention and Court of Human Rights is a good thing. And interestingly, I mean, it's sort of linked to Prince Charles, I think rather unfortunately comparing Putin to Adolf Hitler, which was not a very sensible thing to do, had the effect of people thinking, wow, hang on, actually, let's have a look at all of this again. So, yes, it'll be around.
Good. Well, that's good to know.
Your blog will continue.
Well, even so, we'll just change the name if it fails. Fiona?
I mean, I would agree with the overall conclusion, diagnosis, which is that the European Convention on Human Rights will absolutely be around in 10 years. I also agree that the UK will be in it. But more concerning to me is whether or not Russia will be in it. Because Russia has an interest in having a zone of destabilized states around it and has no interest really in engaging effectively with the European Court of Human Rights. We're now asking the European Court of Human Rights to give a judgment on Crimea when the European Union has sort of shirked the issue in any kind of meaningful way. So that will create more tension. Either the court will find itself having to do something quite unsatisfactory from a jurisprudential perspective or something really quite tricky from a political perspective. And the risk is that it creates another nudge for Russia to withdraw, either formally or cognitively. And they already refer effectively every single decision to the Grand Chamber. That Russia refers almost every single decision that it's involved in to the Grand Chamber. So there is a real challenge there around keeping other states involved and committed to the convention. Whether or not that will change when the EU finally accedes, which we've been told is imminent for quite a while, and whether that affects the neighbourhood policy and things like that of the EU is a separate issue. But there are risks around reform. The court is very fragile logistically, but it is also fragile politically, and we're not seeing the big picture in this country. We keep worrying about the UK withdrawing. It's not going to happen, but Russia might, and then we'll be in real trouble.
I'm glad that everyone's so positive about the UK. That's excellent. I'll sleep well tonight. Any comments from this side of the table? Okay.
Well, the one thing, just to be, you need to be aware, and Jane may already know this, but there has been a dance between David Cameron and Putin on the European Court of Human Rights and the European Convention on Human Rights. And it is said that the reason that the best candidate put forward by the United Kingdom to be the next British judge at the European Court of Human Rights was not elected, which is Ben Emerson, was because of a deal that was done between Cameron and Putin to make sure that someone else got it, because Emerson was just too independent. in terms of these things and uncontrollable. So there's some pretty nasty stuff going on behind the scenes in terms of deals being done to limit how far the European Convention goes and how far the European Court goes.
Comments from the floor or questions? Can you just take the microphone? Man, second row.
Tom Tarbury, 39 Essex Street. And Philippe and Fiona, just a short question. Just how can you be so confident that Britain won't leave the convention, given the likelihood of the Tories getting a majority with which there won't be a Lib Dem bloc that has kept us in the convention over the past term? Given that likelihood, what would be the barrier? Why are you so confident that we will remain in it?
First of all, membership of the EU, which I know we might not also retain, without membership of the Council is unthinkable. The EU is going to accede to the Convention anyway. And secondly, because I think deep down everyone recognises we're better in than out in terms of the Convention. So I just don't think, I think there's a lot of rhetoric, but I don't think the movement will come. Maybe I'm being overly optimistic, which is an unusual position for me, but I don't see it. There's also the small point of a major international treaty that binds the UK to having an equivalence of rights protection with the Republic of Ireland, known as the Good Friday Agreement, and that is based also on continuing membership of the Convention. That's not nothing, but nobody seems to talk about it.
Because the Tories won't win a complete majority. I mean, they may come in as the largest party. They may come in as the largest party. That is certainly possible. But I don't think anyone assumes they can have an overall majority. Maybe they'll come in with UKIP, in which case you can imagine. But there are a lot of very sensible people in the Conservative Party. There was one member of the Commission who was appointed by the Prime Minister who is an incredibly sensible person, and it is plain that he has a lot of support. And there isn't a sort of monolithic single view on the Tory side of you've got to get out. It is much, much more complex. And the moment that, I must be careful how I characterise these individuals, but the moment that particular group began to see the connections with Scotland, Northern Ireland, which you've mentioned, it's incredibly important, and Wales, where support on the Commission, on participation in the European Convention on Human Rights, on the basis of the consultation that we did, was at near as damn it 100%. From those countries, parts of the United Kingdom, that caused them to blink. And they know that if they want to go down the path, why are they being so quiet right now about the European Convention? Because they know that in Scotland, across the political spectrum, to talk about withdrawal from the EU, to talk about withdrawal from the European Convention, is the kiss of death. And the yes vote goes up dramatically. So what I learned from that experience was I had no idea about the interconnection that you've talked about. I'm much more attuned to it. But I think there are enough sensible people in the Conservative Party who realise that it's actually much more complex, both internally in the United Kingdom and externally in relation to Russia and Ukraine. And simply pulling out, withdrawing, is not a viable solution because it will have consequences that are now pretty predictable.
I want to move on to the final topic because we're nearly out of time, and something completely different. Socioeconomic rights. Are they the future? Are they feasible? Has the recession improved the case or made the or weakened the case for socioeconomic rights? Let's go from this side of the table because we haven't heard much in the last few minutes. Do you want to start?
Yeah. Well, on socioeconomic rights. I always had some reservation about how economic rights is being discussed in the multilateral fora and how it is addressed on the bilateral forums. And then we have to look also at the history of economic rights. How did economic rights start within the UN system? It was basically at that time, it was during the Soviet era where Soviet republics were pushing for economic rights. On the other hand, Western countries were pushing for political rights, and eventually both rights evolved with the both convention being adopted in the 1970s, Convention on Civil and Political Rights, also the Convention on Economic and social, cultural rights. But then we have to see like who are the proponents of economic rights at those times, and whether like the discussion we are having here right now within the UN system is really relevant to what is happening in the real world in terms of promotion of economic rights. Basically, the proponents at that time was basically state-owned economies, which had a vision of economic rights. But now we are living in a market-free-based economy, which there's another vision on how like economies should be run. Economic rights, within the level, is the absence of economists and people dealing with economics on economic rights. Give like it's a very futile debate. For example, if I take the issue of the right to development, which seems very appealing while everyone wants to develop. We have seen since the adoption of the declaration till now, last week there was a working group on the right to development. You can basically see this disconnect with member states within the UN and what is happening really on the ground in terms of economic rights. I take the case, in the UN you have this big north-south divide about economic rights, but when you go and see like the relationship between, for example, Europe and African countries, for example, through the Cotonou Agreement, or the US with sub-Saharan African countries through the African Growth and Opportunity Act, but you do seem like economic rights are being promoted. And this is where economic rights is linked with economic governance. Economic governance means how much GDP a government is putting on its housing budget, how much GDP is putting on its education budget, how much GDP is putting for its economy on health budget. And this is a debate which is not really happening within the UN, which we see the most theoretical part is killing the practical part of economic right. Again, but we have like this acceptance of independence, and this is true. You need to have this independence between civil and political rights and economic rights. I'll give you the case of two countries, and I take my country, Mauritius and Tunisia. When both of us got independence, Tunisia was run by a dictator, but they were promoting more economic rights. Mauritius got independence, started to focus more on civil political rights, to build an independent judicial system, to have free and fair elections, to bring the government accountable, to have a free press, and everything. But with time, you can see, basically, if you don't have civil and political rights, a country will just focus on economic rights, eventually the society will crumble because you don't have a system of accountability in that. So this is where like the whole issue, and with now the post-2015 coming up, it has to be resolved. What do we really want in economic rights? And do we not need to be more practical rather than going on long and theoretical discussion of what is economic right? Because economic rights is linked with economics. And this is where the committee also, which is a committee on economic, social, cultural rights. Basically, you have a committee with members, but no one has an economic background. So how are we talking about economic rights with people just with legal background? So this is an issue. Yeah.
Not true?
No, I think they do. In fact, members of that committee are quite attuned to these things. I thought this was an extraordinarily strange question because I thought this is over. We have economic and social and cultural rights, and civil and political rights there are positive and negative obligations with regard to both families of rights. There's been an enormous amount of work done with respect to even cultural rights. And interestingly enough, the sponsors of these resolutions are those really, really pinko lefty type places like Germany and Spain. I mean, we're not. I think there's a lot of misconception. I believe that there are many who would consider that most of these mandates are created by one particular country, but this is not the case. And we now have an optional protocol to the Economic and Social and Cultural Rights Covenant. We've had the decisions of the various treaty bodies, the Women's Convention on Treaty Body, also the treaty body with regard to disability, and they have made decisions with respect to economic, social and cultural rights. So I was somewhat surprised. I thought you would ask a question like, is the right to peace the future, or something of that nature? But so just a bit shocked, sorry.
Anyone else on this point?
No, well, I'm surprised by what Jane's just said. I thought this was a great question and a very timely question, because I think it's not just a north-south issue internationally, it's a north-south issue in this country. One of the things that we've come to understand is that inequality is a real problem. And inequality in this country is a growing problem, and that we sort of have a sense that when levels of inequality get bigger, disturbances become more frequent within a community and within a society, both internationally and internally. And I think if you go around this country, now it's very interesting, again, comes back to being on the Commission on a Bill of Rights. What did people care about the most in the consultation? The National Health Service. Access to medical treatment. It was really striking. That was the issue when we had public consultations. That's what people care about. They care about, basic access to resources like that. That's an economic and social right. It's not a civil and political right. And I think that the future wave will actually be, as the inequalities in this country and in the United States become bigger and bigger and bigger, the real demand will be for economic and social rights, not protection against surveillance, not privacy. Most people don't care about that. What they care about is a home to live in, water to drink, a hospital to go to if they're sick. And it's very understandable. If you have no wealth, that is what really matters. As Subhas quite rightly says, it's not just a north-south issue and not just a global issue.
Comment from the floor? Yep. We just wait for the microphone.
Thank you, Julia Truhl. Just to that point, just that you made, I think it's very important to consider climate change in that whole discussion, because we will have climate migrants, and it might be the English people leaving the island because they're drowning here and the Scottish won't let them in, so they have to go to France. But it also could be the people from sub-Saharan Africa who at some stage might build some bridge that they don't all drown on their way to Europe. There will be significant issue of rights of those climate victims to food, to shelter, to have peace, to live somewhere, for not being shouted at by UKIP people. So I think that's the big elephant in the room, which should be addressed with that rights issue, human rights for everybody on a completely different level.
Just one more comment, I think, that the lady behind.
It's more of a question. I work at a predominantly legal aid firm, and currently at the moment there are huge attacks on legal aid and also simultaneously on judicial review, and it's perceived by many as to be an attack on the rule of law. I'm interested in how the panel think that people in this country and also around the world who I think have less developed legal aid systems can access human rights mechanisms without access to good quality legal advice. That's my question.
And can we have very short answers to that, because we've run out of time?
Sure. I mean, I think that it's an enormous problem, and one of the reasons why the European Court of Human Rights in Erie said you have to be able to access civil legal aid. The difficulty, and I will be very short, is that so much of that work will now become a burden for civil society and NGOs, which are also under-resourced and undergoing a crisis in terms of their capacity. But that will be the way, will be through NGOs and civil society and people in practice doing lots of pro bono work, but that is difficult as well. But the burden will fall on civil society, I think.
I think with regard to the international mechanisms, civil society does most of the work, and we have some nice, generous lawyers who are prepared to put through the cases and through the communications. There's no legal aid available at the international level.
I think that we're going to finish there, because we do need some time for drinks and canapes. Although we could go on all night. Sorry, and of course, buying the book. Rosa, will you be available to sign?
Absolutely.
Okay, excellent. Thank you so much, and thank you to BLP for hosting us, incredibly kind, and they provided everything for free. So an example of the civil society that Fiona was talking about. Thank you so much to everybody who sat on the panel. Thank you to Rosa for giving us the opportunity to have this event. And thanks very much to you for all of your contributions. And do join us for a drink.